Well, now to discuss this further, we are joined on the phone line by Amnesty International's Africa Director for Research and Advocacy, Nesanit Belay. Good afternoon to you, and thank you for joining us here on ANN7. Now, in the world's view, how will South Africa be perceived if a negative verdict is given against the government?
Obviously, once again, it will be another affirmation of South Africa's utter failure to live up to its international obligations. And indeed, it should amount to an embarrassment to the government for its failure in many respects. And most likely, as many people are expecting, the outcome will be a finding of non-cooperation on the part of South African government. It doesn't necessarily mean that this ruling might be the last one, as the court might give the verdict with a leave to appeal before the ICC Appeals Chamber. But nonetheless, if indeed the outcomes happens to be a finding of non-cooperation, once again it affirms what all South Africans and the rest of the world knew, that South African government had the obligation to arrest Omar al-Bashir upon arrival.
Was the government justified by leaving the Rome Statute? And with regards, and more importantly, are there suggestions that the court only persecutes African leaders?
Well, to answer your first question, we do not believe so. We're yet to see the court's outcome, but we do not believe that South Africa has any legitimate, justifiable reason not to have arrested and surrendered Omar al-Bashir. The law was clear, international obligations are clear, the domestic legal obligations were also clear. So I think that will be affirmed through the court outcome. With respect to the ongoing debate, perception around the ICC's workings and in its alleged targeting of Africans, much debate has been had on this issue, as you know. I think it's useful always to remind audience the facts themselves, the history of how all these cases before the ICC came about. As you know, most of the cases with respect to the African situations were self-referrals, where member states themselves called upon the ICC to step in and help them. And there are, of course, a few cases where the UN Security Council has referred matter to the International Criminal Court. But once again, we believe that's unfair to target the ICC in this regard. What needs to be blamed for a double standard in referring cases to the ICC is the UN Security Council, and Africans have a rightful reason to criticize the UN Security Council's use of veto powers and its double standards in the way it operates largely. That is definitely a question that needs to be raised and reform needs to be solved. Other than that, the single case where the ICC has initiated by itself an investigation with respect to Kenya, that also has a long history that explains how the domestic lawmakers themselves have sought the ICC's intervention itself, and where the case pursued and concluded without the government itself refusing to cooperate with the ICC, at least in terms of making sure the defendants are before the court of law. That ought to have been a lesson for South Africa as well, in the sense that even head of states need to face justice if and when the court issues arrest warrants.
Just lastly, Mr. Belay, with regards to the verdict and the possible outcomes of that, what could the court possibly impose on the country with regards to that verdict?
Well, as I said, various scenarios could play out today. Most of us are expecting that the court will find South Africa having failed to cooperate with the court as per its obligations under the Rome Statute. It's unclear at this stage whether the court will hand down its verdict with a leave to appeal the decision before the ICC's Appeals Chamber. If that happens, then the South African government might resort to appealing the decision before the Appeals Chamber. The debate, this issue, is not the first time that has come to the ICC, as you may know. In previous ICC pre-trial chamber decisions, where two governments, DRC and Malawi, failing to arrest Omar al-Bashir as well, decisions were handed down on their failures as well, similarly. So there are very much similar legal arguments currently before the ICC, and it's most likely that the decision might be similar to the previous decision that was taken. Indeed, South Africa has a different argument that it presented, in arguing that the consultation process that happened with the court was unfair, and we're yet to see what the court will decide in that regard. Yeah. And if once this non-cooperation is finding, the court might resort to referring the situation to the Assembly of State Parties, which is the governing organ of the Rome Statute, for some kind of political action and sanction against South Africa for its failure. That doesn't mean that the Assembly will be calling upon suspension or anything otherwise. To the contrary, actually, the Assembly will be encouraging South Africa to constructively engage with the court and never again make this shameful mistake that it has done in the past. And the scenario will be for the Security Council to be called upon to enforce the decision, but that's yet to be seen whether that's the direction that will follow.
Well, thank you very much, Mr. Pillay, for your time and unpacking those details for us. That was Amnesty International Director, Mr. Netsanet Pillay, talking to us about the International Criminal Court today delivering its judgment on the matter of South Africa's failure to arrest Sudanese President Omar al-Bashir. We will keep you up to date with the latest details and developments. But let's discuss this further. We're also joined on the phone line now by African analyst Dawa Vinga. Good afternoon to you, and thank you for joining us here on ANN7. First and foremost, what is your view on the matter before the ICC court today?
Thank you. The chances and likelihood is that the judgment from the ICC might very well be in line with the rulings by South Africa's own domestic courts that indeed South Africa had a legal obligation to act on Sudanese President Omar al-Bashir when he visited South Africa in 2015.
With regards to the various criticisms that we have heard, there is criticism that judgments from the court are mostly against African leaders. Is there any facts behind these statements? Is this founded?
Well, as the Amnesty Africa Director for Research and Advocacy has said, in a closer look would reveal that, in fact, past investigations and prosecutions, although they have mainly been on the African continent, they have in fact been largely at the invitation of the African countries concerned, and this is the case with Kenya, with the Central African Republic, with Uganda, and with many other areas. So it might appear to be that, and if there is pursuit of a purely political argument, there is resonance, but in fact this would be inaccurate information.
Do you think that the judgment will serve as an example to other member states who do not toe the line with regards to the rules of the statute?
Well, the judgment would most likely be looking strictly at a legal framework, and this is where the concern is, that South Africa might then look at a political trajectory, and this might then in fact revive the discussions internally within the ruling ANC party about withdrawal of South Africa from the ICC, which in the first was unprocedurally done and had resulted in South Africa revoking its withdrawal notice to the UN. But in terms of a broader look, certainly yes, it might be a deterrent to other African states. But I think what is important to look at also some of the valid criticisms of the need for the ICC to be reformed internally so that it can become more effective and efficient as a mechanism for global justice in terms of perceptions and in terms of global reach of its investigations beyond Africa, which it has begun to do by looking at investigations, for example, in Georgia, or abuses by Iraq by the UK soldiers, or in Afghanistan, and so forth. So that is where the ICC needs to be going to in order to internally address some of the valid criticisms that have come forward.
Some other criticism has also come to the fore with regards to the courts such as this, calling it toothless bodies. Do you agree with statements of this nature? What is your view?
as a global body, there is a need to perhaps have a balanced and fair look at what it has achieved. But that criticism might actually relate more accurately to the unbalanced global geopolitics, where, for example, some of the most powerful states in the world, like Russia or the U.S., that are members of the Security Council, have the power to prevent their allies and themselves from the reach of global justice or from referrals to the ICC. And at the same time, they also have the sort of unfair power as the UN Security Council to make referrals in terms of which situations the ICC should investigate. So there is a valid criticism of the global geopolitics, but this would be invalid if it were to go as far as to say, therefore, global justice is not essential. What is needed, we believe at this point, are more platforms for global justice and less, not less, and also to acknowledge that the International Criminal Court has a complementarity role, which is that first and foremost, domestic and regional courts have that responsibility to prosecute and dispense justice, but where they fail, then there must be recourse as a court of last resort globally to the ICC.
Well, thank you very much, sir, for your time this afternoon. We appreciate you talking to us. That was Mr. Dawa Mavinga talking to us about the International Criminal Court today, delivering its judgment on the matter of South Africa's failure to arrest Sudanese President Omar al-Bashir. Stay tuned to ANN7. We will keep you up to date.